And this is another thing that I have to stress as well. That once you have these contracts drafted, as your business grows, you have to have an attorney review those contracts and keep updating terms and so forth. That is so important. I take a look at these contracts and, can you hand this to Josh? Thank you so much. So not only drafting, but reviewing all the terms of these contracts and updating them. Another one is a change in healthcare law. I get these old contracts, and believe it or not, there's still a lot of contracts floating out there that are not HIPAA compliant, which in itself could bring down federal, state, and local agencies on you for violation. Or you can get sued by a private party for violation of their privacy. So that's another huge issue that's always ongoing. One of the other agreements that a lot of people don't think about are relocation agreements. You have a lot of employees. If you have a big manufacturing firm or hospital network, more than likely you're going to have employees that are going to be moving around. So again, you should always put everything in writing. So rule number one, just to repeat for some people who just walked in, should always use an attorney, a highly experienced attorney that's within your industry. And number two, always make sure you get it in writing. I cannot emphasize that enough. Always get everything in writing. If you don't pay for it in the front, you will pay for it in the back with litigation that costs even more money. Okay, some of the other agreements that you're looking at, there's what's known as joint venture agreements. You may be wanting to talk about someone, wanting to do business with them. So the first thing you want to do is have that NDA, have them sign an NDA. Then number two, you're talking about a joint venture agreement. You can have a small agreement between you that you are exploring a future business relationship. There are certain terms in there that will protect you and that other party. Again, if you don't get it in writing, it's hard to litigate. Another contract that you want to take a look at is purchase and sales agreements. So many times I see manufacturers up and down the product line, and they use a lot of IPOs and purchase orders, but they don't have a formal agreement with a supplier and or their downline customer. Now, if you have a couple of $1,000s worth of product out there, you're not going to spend the time to do that. But if you have clients and you're developing that business and business is growing, and again, you've got to have something in writing known as a purchase and sales agreement. Here's another contract that a lot of manufacturers and individuals don't know about. You can have what's known as an exclusive manufacturing or service contract. So one party will either manufacture or handle all the services of that one particular need of company. That's called an exclusive contract. Other contracts that you can think of, they're out there. Physician agreements, that's huge. If you're a physician and you have a referral system or you're referring clients out, always got to have a physician agreement in writing. Now, I've seen physicians out there, and a lot of them now are starting to use client agreements. Client agreements, if you're a physician and or hospital, whoever your end user is, it's also known as an end user agreement. You have them sign an agreement that states their rights of privacy. That's an important thing to disclose. And also, what do you do for non-payment? And also, what are their other rights with this agreement, and what are your rights? And a lot of times I go into physicians' offices and they have nothing in writing. So again, if it comes to litigation, basically it's going to be an oral contract, and really he said, she said is not in a position that you want to be in. You guys are understanding the importance of using a lawyer and using contracts, and they're just so important. And I know a lot of people sitting in the audience saying, I just have a small business and so forth, but another aspect is you don't need to have a 100-page contract, okay? You can just start off with a 3 to 5-page contract. That's one of the things I do too, is if you're a small to medium-sized business, your sophistication grows as your business grows. That's a huge point. If you're gonna write something down, write that down as well. As your business grows, your contracts will directly become more sophisticated, okay? So you don't need to go out and spend 20, 30, 40 grand on all these contracts. You're just starting out, you spend 2,500. You know, what's more important? Okay. So we talked about what are some of the important kinds of contracts out there. I want to talk about some of the terms that are in these contracts. Okay, so again, I want to repeat this. I want to make sure everyone hears this and everyone writes this down. One of the most important terms that you can put in a contract, again, is going to be venue and jurisdiction. Where is this dispute going to be held? I can't emphasize that enough. Make sure that's in every contract. Here's another one. I represent a variety of clients. One of the things that I want in all of my clients' agreements are attorney's fees. If there is a breach of this agreement, not only will this agreement be held in the state of Illinois, like Lake County or Cook County, I will also be entitled to attorney's fees for the non-breaching party against the breaching party. That is so important. I can't emphasize that enough. I use it as a bargaining tool. If someone breaches a contract, let's say it's only for $5,000, but they're facing attorney's fees that could be in excess of that $5,000. I go to court, not only do I get attorney's fees, I get costs. But those attorney's fees, after you're in court 5, 10 times, that could be $10,000, $12,000. And it's a $5,000 contract. So not only does my client get paid back, but it's also a negotiation factor. So when someone breaches a contract, I'll go in and I try not to start off so heavy-handed, but I'll say, look, you breach this contract, you're facing attorney's fees plus damages. If their behavior is so outrageous, sometimes in contracts I'll put in that you can go after for punitive damages. That's huge. That's another thing you may want to put in your contracts. So that's a punitive factor. So not only are they facing a breach of contract, they're facing damages on top of that, 3, 4, 5 times. Again, it's a deterrence factor. Now, another important term within that contract is the length of that contract. I can't tell you how many times I review contracts, they never put a termination date, or they never put an automatic renewal term. This is a red flag. No matter what business you're in, no matter what contract you're signing, I don't care if it's for a cell phone, I don't care if it's within the healthcare industry. The first thing I look at, when does this contract terminate, or does it automatically renew? You ever get caught in that where you sign up for some good or some service and you don't read the fine print, and on page 23 and 6 font, you never read it, and they automatically renew that contract at a cost of $500,000 whatsoever. I know a lot of contracts out there that are under an automatic renewal. Okay, I don't want that in any of my clients' contracts. I want them to contact me 60 or 90 days before and let me know this contract is up. I like to review. So if it's an employee contract, then you may want to be able to have an automatic renewal of that contract. Okay, so that's very important as well.